Madam Speaker, I am grateful to my honourable friend, the member for Harwich, for providing an opportunity for me to respond to the points which he has somewhat vehemently raised, in the particular case of the firm of Animal Aunts, and also for the opportunity this gives me to say something about the importance which I attach generally to the correct determination under the law of individuals' employment status for national insurance, whilst at the same time seeking to ensure that the mechanisms for doing so are not unduly bureaucratic or burdensome. This case is all about whether pet and animal sitters, or aunts as they are called, supplied by the firm Animal Aunts, are to be treated as self-employed earners responsible for their own national insurance contributions, or, as my honourable friend vigorously contends, whether they are to be treated as employed earners for national insurance purposes with the firm of Animal Aunts, and therefore liable to pay full Class 1 contributions on their behalf. Class 1 national insurance contributions are, of course, the most widely paid class of contribution, paid by virtually everyone in a job and by office holders such as company directors or indeed members of Parliament. Well over 1 million employers regularly deduct and pay over these contributions to the tune of nearly £40 billion per year. It is virtually part of our culture to pay these contributions, and if anything, attention more often focuses on instances when employers fail to meet their obligations to pay contributions in respect of their employees. We have seen, for instance, reports by the Controller and Auditor General pinpointing certain shortcomings in the contribution collection system, and it is to the public credit of my department's contributions agency that they are addressing these with vigour and that they are meeting or exceeding the various high-level targets which are published. But in saying this, I do not seek to undermine my honourable friend's stance in the Animal Aunts case, but simply, Madam Speaker, to place it in context. I should also like to remind the House about the purpose of national insurance contributions, which are at the very centre of this debate. Unlike taxes, which are raised by the Crown with the consent of Parliament to provide monies for the general purposes of government, the national insurance system is an entirely separate one, providing pensions to the retired and short-term contributory benefits to those who are sick or unemployed. These benefits are funded from the National Insurance Fund, which is directly financed by the contributions paid in by employers and those in employment. The National Insurance Fund is, as its name denotes, an insurance fund over which the Secretary of State has powers of control and management. Entitlement to benefits from the fund depends upon the amount and class of contributions paid, and there is an important distinction here. Employed earners who have paid full Class 1 contributions are entitled to the full range of contributory benefits, but the Class 2 contributions paid by self-employed persons do not earn entitlement to employment benefit or to SERPs. Moreover, self-employed persons who suffer from an accident at work cannot qualify for disablement benefits under the Industrial Injury Scheme. So it's very important from the individual contributor's point of view that they are correctly categorised for national insurance purposes. We have heard much about the interests of the firm, but we also need to consider the interests of individuals and the benefits which they may or may not accrue according to which contributions they pay. And indeed, a considerable number of disputes arise from cases where workers have been treated as self-employed persons, suffered an accident at work, and then found that they're not entitled to benefits under the Industrial Injury Scheme. Of course, in the vast majority of cases, it's abundantly clear which is the correct class of contribution due. A person usually is either working clearly under contract of service to an employer, or he is on business on his own account and therefore an independent contractor. However, the government are conscious that there are grey areas. And picking up the deregulation point which my honourable friend made, we have sought to make it as easy as possible for people to get authoritative advice on their status. Thus, in each tax and social security office, there is one particular person who is responsible for all inquiries and decisions about employment status. Anyone in work can get a written decision on their employment status from either the Inland Revenue or the DSS. And my department and the Inland Revenue have got together to produce a joint leaflet giving extra guidance. I will come later in my speech to the special position of employment agencies. But whilst on the subject of deregulation, I should just like to mention my department's employers panel, with whom we consult regularly on a wide range of issues. The next meeting of the panel is to be on the 25th of May, and subgroups of the main panel meet on specific issues, and small businesses are represented on that panel. Arising from our commitment to the government's deregulation initiative, we are eliminating from this April some annoying differences in definitions of earnings and expenses between tax and national insurance. Madam Speaker, I have described in some detail the general provisions which govern employment status, but there is a particular provision which is relevant to this case. It deals with the special circumstances of employment agencies who supply workers to third parties. By way of further background, the House should be aware that the special provisions embodied in the Social Security Categorisation of Earners regulations exist with the aim of achieving parity of treatment for workers under the Social Security scheme. Thus, for example, a relief typist or secretary supplied by an agency and working alongside other office workers under similar conditions is treated as an employed earner for the purposes of national insurance by virtue of the regulations, notwithstanding that she would otherwise be a self-employed earner because she is not under a contract of service to either the agency or client firm. Following a query from one of the aunts late in 1987, my department made detailed inquiries into the terms of engagements and eventually concluded late in 1989 that the provisions of the regulations I have referred to were satisfied and that the aunts should be treated as employed earners for national insurance purposes. And I should like to say a little about the contribution agency's conclusions. Regulations 2.1 and 2 of the Social Security Categorisation of Earners regulations provide for persons to be treated as employed earners in respect of any employment falling within column A of Part 1 of Schedule 1, provided the person is not within the exceptions specified in the corresponding paragraph of column B. And it was concluded that the aunts fell within paragraph 2 of column A, but that the exceptions in column B did not apply. In particular, one condition which had to be satisfied was that there was no ongoing financial interest on the part of the third person. However, under the terms of the contract with the client animal aunts, under the terms of the contract with the client, animal aunts collect further fees if an engagement is extended or renewed at a later date, and therefore maintains an ongoing financial interest in the employment. Subject to the ruling being operated by the firm, the department agreed not to pursue the question of arrears at that time. Rulings of this sort are administrative in nature and have no force in law. However, there is the right to have the question formally determined by the Secretary of State, as provided by Section 17 of the Social Security Administration Act. And the Secretary of State's function is to determine a question raised by a contributor. There is no provision for the department to raise any question itself, nor to participate in the proceedings as an interested party. The jurisdiction is not to adjudicate in a dispute between the contributor and the department, but to investigate afresh all the facts relevant to the question and reach a conclusion as to its appropriate determination in the light of all the relevant facts and applicable law. In carrying out those functions, the Secretary of State has power to appoint a person to hold an inquiry into the question and report to him. Such inquiries are inquisitorial in character, and they form part of the process of determination. The possibility of a formal determination in the animal aunts case was quickly mentioned in ensuing correspondence between the department and the firm's accountants. But the correspondence became somewhat protracted as the accountants queried the application of the regulations and the department responded. And far from hounding the firm, as my honourable friend has suggested, I think it would be right to say that the department took considerable time and trouble to examine every representation made on the matter, but finally remained of the view that the facts did not allow another conclusion to be reached. It was more than 2 years later that the firm eventually applied for the matter to be formally determined last May. Further delays took place, but the inquiry was held last month. And here I am pleased to be able to tell the House that the inquirer's report and recommendation have been received, and it was possible for the formal decision to be given yesterday. This has been dispatched to Animal Aunts and will hopefully arrive in the first post this morning. But I have pleasure in informing the House that the aunts who were the subject of the application have been found not to be included, or treated as included, in the category of employed earner for the purposes of Social Security Acts. And I'm pleased upon that announcement to hear the first kind words from my honourable friend in this debate. In other words, the Secretary of State has found in favour of animal aunts. If I may say so, Madam Speaker, I think this is particularly significant, given my honourable friend's concern about the independence of the decision-making progress when the Secretary of State might be held by some to be judge in his own cause. It is not uncommon for the Secretary of State to overturn the Department's view. The improvement rate, as it's called, by the Secretary of State, for instance in 1991-2, was such that 36% of employment status decisions resulted in the Department's view being overturned. That is a very much higher percentage than my honourable friend suggested. My honourable friend also made the point that where there is reasonable doubt about the applicability of a regulation, the benefit of that doubt should be in favour of the side which creates or preserves jobs and profitability. Madam Speaker, there are wider issues here which it would not be appropriate for me to try to answer, but I do think that if one were making such a proposition, then an equally strong argument could be put forward for giving the benefit of the doubt in such a way as would protect the benefit rights of the individuals concerned. Finally, Madam Speaker, I pay tribute to my honourable friend's enthusiasm in pursuing the Animal Aunts case so vigorously, but I also pay tribute to the entrepreneurial spirit of its proprietor. Let there be no doubt about that. The last thing my department wants to do is to harass small business.
Thank you.
Order, order. House stands adjourned.